Here's another thing that you should know once you have your bank account levied, which is always obviously very distressing and many times very difficult to understand and know how to respond, or if to respond at all. The response is a claim of exemption. Anytime that a consumer has their money taken, you can do a claim of exemption and ask the court to return the money, some or all of it. Certain types of money is exempt. That's why it's called a claim of exemption. For example, if the source of the funds is Social Security or veterans benefits or workers' comp, those sorts of things, then yes, those are exempt and you should get those monies back. The question is, what if it's not exempt? And there's a catch-all. You can always ask the court, say, my financial hardship is so difficult I can't do without the $4,000 or whatever it was that was taken on my account. That was going to be for rent. So the question becomes, do you do the claim of exemption? And sometimes it's not prudent. You may win the claim of exemption. You may get some or all of that $4,000 back, but to do so, you have to reveal all of your financial information. So if you do a claim of exemption and you put on there what you make and what your wife makes and what your income and what your expenses are, then a creditor will now have that information. So they know now how much you make. So if you fill out the claim of exemption forms, you're telling the other side all of your financial information. And many times that's not a good play. Certainly depends on your circumstances, right? If there's little or no income and a large family, and the hardships are real and significant, then certainly. But other times, if you're making, have a decent job, a salaried position, 60, 70, 80,000 or even more a year, and your spouse is also employed, and you have a number of vehicles and you have property, if you have property, you may have to reveal to the other side you have property. Next thing they're going to put a lien on that property. So even though you may be successful in getting the money back, and by the way, the more you have, the less likely that you'll be successful in getting that money back. But even if you are, you've just now given the judgment creditor, somebody in a very powerful legal position, the tools to collect against you. So it's not automatic when you have money taken from you that you should try to get it back. Sometimes the better part is to let the levied sums go. It's a wake-up call. You have to resolve it. Engage in resolving it with them rather than doing the claim of exemption. It's a tactical call. And you're going to want to know, what is a judge going to do or not do? You want to talk to somebody who's been in front of the judge before, who makes those decisions about returning the funds or not. And I will tell you, if you have a decent income and you've got property, you have other assets, the court's inclined that you pay the judgment. Judgment is a court order. So most judges are going to order you to pay that. Most judges are going to say you must pay your judgment creditor before you pay your other unsecured creditors. Many people put in their claim of exemption that they have credit card bills. They're paying $2,000 a month to their other current credit cards. The court's position is that judgment creditors get paid before your other unsecured creditors who haven't even taken it that far. So the decision to file a claim of exemption, really need to talk to somebody who's been there, done that, to make sure you don't make it worse.